Forced reset triggers are back on the menu, and even if you don't own one, stick around because this case is going to potentially impact you because it could be heading to the Supreme Court. Before we go any further, don't forget, if you're a Wisconsin resident, check out counterpointseminars.com, a sponsor for today's video. Otherwise, guys, let's get into it. So I'm going to give you the outcome first summary for people who only want the outcome. So on October 7th, this past weekend of 2023, the Northern District Court of Texas ruled that the ATF's expanded definition of machine gun is likely unlawful and a breach of the Administrative Procedures Act because the legal and statutory definition of a machine gun unambiguously turns on the movement of the trigger and not a trigger finger, as the ATF is trying to make it, so the court has ruled. This creates friction between statute and the ATF regulation and thereby makes the ATF's interpretation illegal thanks to the APA, again, so said the court. The preliminary injunction now has expanded the existing temporary restraining order that was in place from August to enjoin the ATF and DOJ defendants from implementing or enforcing in any civil or criminal manner whatsoever their interpretation of forced reset triggers as somehow being machine guns against all protected groups. So who are the protected groups? Protected groups include, from pages 44 to 45 of the linked decision in the description box below, individual plaintiffs and their families, the organizational plaintiffs and their members, and the downstream customers of any commercial member of an organizational plaintiff. This means for $35 per year, you now have the opportunity to support yet another fantastic pro-Second Amendment group because you can join the National Association for Gun Rights, NAGR, who was one of the lead plaintiffs in this case, and give yourself a strong layer of protection if you just found your FRT or WT trigger from the bottom of that lake where you had that boating accident. Now, as a note, I did talk to a very friendly and helpful person at NAGR who confirmed that it is their interpretation, as well as my own, that if you join today, that you can, of course, be protected. Check your own listings, of course. Not licensed in 50 states. So there you go. That's the super short version of the outcome. Now let's talk about all the important why and how for those of you who have an attention span beyond 90 seconds. History determines future. And what I mean by that is if you want to see where we're going, look where we have come from. Now that is true whether we're talking about at the macro geopolitical global stage or maybe in the legal proceedings just like these. The history of the law and the corresponding ATF regulation is critical to understanding both this FRT issue as well as why so many folks get so frustrated with the ATF, who've been accused of trying to absorb multiple branches of government all into one entity their own. Stick with me and you will see how. I will make it as short and painless as possible. The history. Let's start with what the definition of a machine gun is, found at 18 United States Code section 922 sub O sub 1. A machine gun is defined by the National Firearms Act as any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. That's going to be the key part. By a single function of the trigger, not a single pull, but a single function of the trigger. For decades, the ATF regulations more or less copied the federal statutory definition of what is a machine gun. However, that all changed when the ATF expanded their regulations, even though the statute did not change back in 2018. The ATF added into their regulations, which are not law, but they are interpretations of the law. Quote, for purposes of this definition, the term automatically, as it modifies shoots, is designed to shoot or can be readily restored to shoot, means functioning as the result of a self-acting or self-regulating mechanism that allows the firing of multiple rounds through a single function of the trigger, and, quote, single function of the trigger means a single pull of the trigger and analogous motions, end quote. Now, of course, ATF went on to helpfully add, quote, the term machine gun includes a bump stock device, a device that allows semi-automatic firearm to shoot more than one shot with a single pull of the trigger by harnessing the recoil energy of the semi-automatic firearm to which it is affixed so that the trigger resets and continues firing without additional physical manipulation of the trigger by the shooter, end quote. Now, included in the description box below is a more detailed history of ATF's Firearms Technology Criminal Branch and later the ATF's Firearm and Ammunition Technology Division, as they basically took this newfound expanded interpretation of looking at how your finger works as opposed to how the trigger functions, and then connected the dots and said, bump stock FRT all illegal. Let's move to some legal analysis. So in English, the legal and statutory definition of machine gun, as we said before, unambiguously turns on the movement of the trigger and not a trigger finger, as the ATF is trying to make it. This creates, as I mentioned, friction between the statute, as enacted by Congress, and the regulation, as enacted by the ATF. Now, there's a golden quote coming up, so I want to put you on alert for that. But first, I don't normally talk about standing in cases because, frankly, it's usually pretty boring, technical, the analysis is basically too long, and it kind of misses the big picture. This time, I will pause and share and comment something about the standing. And I hope you will too, by the way, by hitting that like button. Let me know what you think about all this in the comment section below. The decision starts by reviewing a tussle about whether the plaintiffs, that's the good guys suing to do away with this, have standing to file the lawsuit. Now, as I mentioned, this is pretty standard stuff for lawsuits of this nature when the defendants, that's the person or group being sued, in this case the DOJ and the ATF, claim that the plaintiffs lack standing to sue them. In court, you see, you need to have standing to bring a lawsuit. I can't just sue someone who blew a red light and hit another person unless I have standing. I have enough of a connection to the aggrieved party to bring that lawsuit. Otherwise, you can imagine the legal chaos that would ensue if anyone can sue anyone at any time for any reason without standing. So that's the concept, and it's basically the court's jobs to more or less safeguard that standing issue in order to protect our system. Now, the thrust of what I want to touch on here is that the DOJ was contending that the plaintiffs lack standing because any prosecution against them for possessing FRTs, forced reset triggers, was strictly hypothetical, and that it would upset the balance of power if courts could just arbitrarily review criminal issues in non-existent prosecutions under hypothetical situations and scenarios. However, there is a lane that the court and plaintiffs point out whereby it can exist for criminal issues, particularly where constitutional rights are concerned, and that someone does not need to wait to sue from behind bars to satisfy the requisite standing issue. But we're going to continue to sharpen this pencil, so you need to sharpen up and listen because my favorite part's coming up. As the court points out, it is in fact the ATF who is in violation of the separation of powers by expanding the statutory definition of what is a machine gun as if they were somehow both the legislative branch and then as well as the executive branch, as if they were the branch of power that creates law and then enforces it. Now, our very system of government, as the DOJ brought up when challenging standing, is premised on a separation of innate government powers into three different but co-equal branches to prevent the accumulation of too much power into too few hands. As the court quoted James Madison as warning, and this is my golden quote here, quote, "The accumulation of all powers, legislative, executive, and judiciary, in the same hands may justly be pronounced the very definition of tyranny." That was in the Federalist paper number 47. The ATF is allowed to make reasonable interpretations of the existing statute under their powers as one of the country's hundreds and hundreds and hundreds of agencies, but they cannot expand the statute as they did when they changed and expanded the definition from one function of the trigger to a single pull of the trigger. The statute regulates the inner workings of how the firearm actually operates, whereas the ATF's interpretation is trying to change to look at how the perceived operator input works, in this case, the finger. Then the court basically brings the boom down. The court is bound by the Fifth Circuit's recent analysis in the case Cargill v. Garland. That's one we've covered extensively on this channel in the past. That's the bump stock decision. According to the en banc, that means all the judges in the Fifth Circuit sitting together, not just a random sample of three of them like you ordinarily get in most cases. En banc means everyone in the circuit. A weapon that qualifies as a machine gun under the National Firearms Act and Gun Control Act must be capable of, one, firing multiple rounds by a single function of the trigger, and number two, do so automatically. Or in even simpler terms, the NFA unambiguously, quote, requires that a machine gun is capable of firing automatically once the trigger performs a single function, end quote. As the Fifth Circuit's statutory interpretation makes clear, a single function of the trigger means what it says it means, a single function of the trigger. It does not mean a single pull by the shooter. The Cargill case emphatically rejected the ATF's interpretation of what a machine gun is. In fact, the word pull is not found anywhere in the statutory definition, as the judge in this case pointed out. The only place that the word pull exists is in the ATF's broadened regulatory definition just recently from 2018 interpreting the statute. As such, neither bump stocks or force reset triggers are machine guns, says the court, because the devices do not meet both elements of the statutory definition. Number one, capable of firing multiple rounds by a single function of the trigger, and two, operates automatically. Remember, quote, the statutory definition of machine gun unambiguously turns on the movement of the trigger and not a trigger finger, end quote, as the ATF is trying to make it. Now, the ATF tries to argue, as they have before, they do here, and they will again, that the words function and pull are in fact synonymous and therefore the same. And the court basically just says no. At the end of the day, the court rules that FRTs do not fire multiple rounds with a single function of the trigger and do not qualify as machine guns, therefore. For each and every round fired, the trigger moves forward into its reset state and is depressed to release the hammer from its sear surface. Guys, if you made it this far in the video, please be sure to hit that like button. Tell both myself and the algorithm this is worth seeing, this is worth looking at, and this is worth sharing. Also, don't forget to comment below. I try to do my best to get through as many comments as possible. Stick around for a quote of the day. Don't forget, if you're in Wisconsin and if you want to learn about basically our duty to retreat, which you probably didn't know that we have, be sure to hit up counterpointseminars.com, also linked in the description box below, where myself and my colleagues will be putting on an all-day seminar teaching all things self-defense. And now let's get to the bottom line. Once more, Judge Reed O'Connor again proves to be a warrior for the Second Amendment. And once again, the ATF has been called out by a court for their attempt to merge two branches of government into one non-elected entity. The government will invariably appeal this to the Fifth Circuit, where I strongly suspect they will lose again based on, well, all the reasons that we just discussed. Where does it go from there? Well, we saw the same question involving FRT triggers get ruled in the opposite direction in a New York court about 40 days ago. So we may be heading towards what we call a split circuit decision, where two of our nation's 13 circuit courts, that's the federal courts of appeal. Remember, we have 94 district courts, that's the district federal trial courts, then 13 federal courts of appeals, and then one U.S. Supreme Court. That's the architecture that we're working with here. And if two of those 13 circuits have different conclusions about law, which puts us in a preposterous situation where something's absolutely legal to own in one place of the country and a felony in the other, this is ripe territory for the Supreme Court to eventually get involved to settle the issue. However, even if you do not own an FRT trigger, this may directly impact you. Why? Because the case will invariably also touch on and decide issues such as ATF power to interpret and enforce, what accessories are protected under the Second Amendment, and possibly what weapons are, quote, particularly dangerous and unusual, end quote, and therefore not protected under the Second Amendment. I'm not saying that. That's what both Heller and the Bruen decisions have said. Or could be that this may all just be decided on a very narrow APA grounds with limited Second Amendment value per se. But for right now, it appears very doubtful given the convergence of all these different issues, as well as the ATF acting up not only in FRTs and, of course, the bump stocks, but pistol braces. Time will tell. Our quote of the day comes from an unattributed author, quote, "The worst kind of enemies are those who pretend to be your friends," end quote. Thanks for sticking around. I will see you in the comments section, and I will see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.